Hi folks, and welcome back to Contract Law. This is video 3 in the video series for Privity of Contract. And in video 1 we introduced the notion of privity of contract, looking at Party A, Party B, and the interesting problems that the doctrine of privity throws up for us. Then we had a look at Trident and McNeice, and we followed that up with a consideration of the Property Law Acts. Now we come to look at all of the various different other ways around the doctrine of privity. I like to call it necessity is the mother of invention, really, where legislation doesn't come to your aid to get around the doctrine of privity. That doesn't mean that your cause is lost, that's for sure. Over the years, and this was certainly evident from the Trident case itself, there are many common law doctrines that have come to the aid of third-party beneficiaries of promises that they wish to enforce. The first of these is probably the most tried and true, and that is the notion of agency. So we've already come across the concept of agency when we were talking about the Dunlop case in earlier videos. And Dunlop ran the argument that in fact Do was the agent that in effect was procuring a contract between Dunlop and Selfridge. Agency is just a very simple concept whereby one person authorises, that person being the principal, authorises an agent to act on their behalf and create legal relations for them, and the ultimate legal relations will be between not the agent and the party that they contract with, but the legal relations will be between the principal and the person that the agent was contracting with. Really, the agent is just the go-between between the principal and the ultimate other contracting party. Crops up in a lot of different areas of commercial law. Dunlop just used that old agency argument to try and get around the doctrine of privity. We saw wildly unsuccessful in that particular case because why is that? There was no consideration that moved from Dunlop directly to Selfridge at the end of the day. The contract really was a contract between Do and Selfridge. Okay. However, when it works a treat because the privity rule never actually comes into play. You just have, as I said, that contract between the principal and the other ultimate contracting party, both main parties to the main contract. Lovely. All the benefits and burdens contemplated by the contract are enforceable by each other as Party A and Party B. No problems to worry about. One area that tends to get discussed a lot in this particular little corner of ways around the doctrine of privity are exemption clauses. Now, we've already seen these in the Trident case itself, and obviously they can be extended to cover servants, agents, employees, and that kind of thing, as we saw previously. If these people aren't specifically mentioned, then privity will preclude the agent or servant or employee from relying on the benefit of exemptions, exclusions from liability, and that kind of thing. The Wilson and Darling Island stevedoring case is one example there. A lot of the cases in this area are shipping cases. Stevedoring, obviously lots of accidents happen, loading ships, unloading ships, things get damaged, and hence we get lots of litigation. So in terms of exemption clauses, you do need to go ahead and somehow flag the fact that the agency argument is going to be run. And that was set down in Scruttons and Midland Silicons Limited. And in that case, the court held that exemption clauses certainly can cover third-party beneficiaries, and they will be enforceable by third-party beneficiaries if the clause has been drafted properly. Okay, it has to be clear that the party to the main contract, either A or B, whoever's going to be engaging this third party, stevedore, contractor, whoever, has to make clear that they are acting as agent for that servant, agent, or employee, contractor, whoever the case may be. Okay, and there was a series of 4 tests that was laid down in that case, one of which was, does the clause mention the fact that the party to the main contract, so far as that exemption clause is concerned, is intending to cover its servants, agents, employees, and so forth. If that is the case, then that third party can sue to enforce it, no problems. These little things have been called Similair clauses. As I said, work a treat, and they are often used in those kinds of shipping cases where you often need the benefit of exemption clauses flowing through to third parties. Now, that's not quite the end of the technical legal side of the argument in relation to Similair clauses, and I will pick up on that in just a minute to complete the tale of exactly how Similair clauses are enforceable. So, that is the notion of agency. The next way around the doctrine of privity is by using the device of a collateral contract. Now, we talked about collateral contracts in the video series on incorporation of terms, and we saw there the demonstration of a bipartite collateral contract, that is a collateral contract between the same 2 parties as the main contract, in De La Salle and Guildford. And if you recall, in that case we had a landlord and a tenant negotiating about a lease. The tenant signed the lease and said, hang on a minute, I'm not going to hand it over until you tell me that the drains are in good working order. And of course the landlord said, yes, that's fine, the drains are fine. Tenant entered the lease, and of course the drains weren't fine. The court found in that situation that the warranty that was provided, the oral warranty that was provided from the landlord to the tenant, could be enforced as a collateral contract to, and that floated alongside the main contract. The consideration for entry into the collateral contract in that situation was the entry into the main contract. Okay, so consideration for the collateral was entry into the main. In tripartite collateral contracts, you might be able to use them to get around the notion of privity. We did see this also in that same video series in the case of Shanklin Peer and Deetal products. And remember, Deetal warranted that its paint would last about 7 to 10 years. Unfortunately, it only lasted around about 3 months. Shanklin Peer weren't to know that, though. They went ahead, engaged painters for their pier, and stipulated that Deetal's paint should be used. It was used, it was a disaster, and obviously Shanklin wasn't too happy and sued. Now, what did they sue on? Because essentially all they had done is spoken to Deetal, had this warranty provided to them, had this assurance that their product was very good. They had stipulated in their contracts that that paint should be used, but the ultimate contract really was between Deetal as the paint supplier and the contractor. In that contract between Deetal and the painter, there would have been an implied warranty as to fitness for purpose, wouldn't there? But unfortunately, Shanklin was not privy to that contract with all its implied fitness for purpose goodness, And so it sought the device of a collateral contract. And in this case, it was a tripartite collateral contract arrangement. So you had Deetle making a warranty representing that its paint was of excellent quality to Shanklin Kia, and in order to make that warranty enforceable, the consideration for that was Shanklin Kia actually stipulating to its contractors that they must use and buy Deetle's paint. That stipulation and requiring the painter then to go ahead and buy Deetle's product, that was consideration that bound Deetle to its warranty as to fitness for purpose. Yes? Nice little device, and this brings us to the concluding part in our explanation as to why Himalaya clauses work. So if you think back to the topic that we just did on agency, and you think about it, where you have an exemption clause and you say, as one of the main parties to the contract, in relation to this clause, I am acting as agent for my servants, agents, employees, contractors, so forth, and I extend the benefit of this exemption clause to that or those parties. How does that all work? Well, essentially, as soon as that benefited party provides some form of consideration to the person that's going to be providing the benefit of the exemption, then a collateral contract between those two parties will spring up into existence, and the only thing pretty much that will be the subject of that collateral contract will be the promise to exempt them from liability. Yes? Now, there's been some very nice consideration on the question of the kind of consideration that the person that's seeking the benefit of the exemption clause needs to provide to the party that will be doing the benefit of the exempting in order to make this collateral contract spring up. And you saw in our video series on consideration that performance of an existing contractual duty is pretty much not going to be good and valid consideration to another party. However, to a third party, it will be good and valid consideration. So that has been mulled over as one form of consideration. Another form of consideration has been found where the person to be protected by the Himalaya clause essentially wasn't bound to, contractually anyway, to the two parties to the Himalaya clause originally. Yes, they weren't directly contracting with the party that's doing the exempting. In the shipping cases, the owner of the goods normally engages a contractor, a carrier, and the carrier will engage stevedores to load and unload the ship. In that situation, the owner will be exempting the carrier for liability and the carrier's servants, agents, employees. And this little theory about the consideration for these collateral contracts runs along the lines of the stevedore didn't have any liability or obligation to perform contractually with the owner, just with the carrier. And by virtue of the stevedore starting to unload the ship, that act in and of itself was sufficient consideration for the promise to exempt them from liability to then make that collateral contract spring up. Like I said, a very nice, neat little device, and one that I think makes a lot of logic and sense. The next way around, sneakily, the doctrine of privity is simply that of joint promises. Now again, this should be nice and comforting and familiar because it's something that we covered off in our video series on consideration. And it just simply runs along the lines of this. If you have not one but two promisees on one side and one on the other side, might be two, only one of those joint promisees needs to provide consideration in order for the contract to be binding. The other joint promisee can simply kind of tag along for the ride. Yes? Now, in that circumstance, in actual fact, there is not a third party at all, even though one of those joint promisees has provided no consideration. Nevertheless, they are still a main party to the main contract. They are not a third party, and so the whole doctrine of privity just doesn't even cut across that scenario there. Not a problem. Cools and Baggett's trustee is the case on that point. The next way around the doctrine of privity is assignment, and assignment is a bit of a narrow exception to the privity rule in the sense that you can give over the benefits but not the burdens. Assignment, everyone kind of knows what assignment is by gut feel almost, but it's just where one party basically hands over the benefit of a contract to another party. As I said, you cannot assign the burden of a contract to another party. Now, the narrow exception here should be ringing bells because the same kind of exception is in the Property Law Acts. You can assign a burden if it is bound up with and a condition of getting to enjoy the benefit that has been assigned to you. Aspen and Seddon is the authority for that point. So assignment, yes, it's okay. Yes, it will get you around the doctrine of privity, only will work in relation to benefits. But as one of the texts says, you know, it really is a bit of an odd result because it's a fairly simple way of getting around the doctrine of privity. A contracts with B to somehow benefit C. If you left it there, C cannot enforce, obviously, the contract to get their benefits from either A or B. However, if either A or B assigned their legal interest in that contract between A and B over to C, then all of a sudden C can sue to obtain their benefit as the assignee. Very simple little device, isn't it? Really works a treat. Can't be done in relation to burdens. Now, if you want to go ahead and step out of a contractual situation altogether, remove yourself altogether, and plop someone else into the contract in your stead, what you're going to have to do is not an assignment, but a novation. A novation. And a novation, you can probably work it out, novel, new. It just means that you create a brand spanking new contract between the old party and the new party. So you have the original contract between A and B. B wants to step entirely out, give all of their benefits and burdens over to C. What happens is, in the process of novation, you need to get all of those three parties together. The original parties to the original document, A and B, the original contract, A and B, and also the new guy, C, has to come into this agreement as well. Now, in this novation, usually they're done by way of deed. You'll see a deed of novation is quite common. It has to do two things, absolutely. You have to discharge the original agreement, and you have to specifically enter into a new contract between B and C, the original party to the original agreement that's left, and C, the new guy. They have to have a new agreement that is substituting for the old agreement between A and B. Now, if your deed of novation does these things, then it will successfully transfer A's interest in the original contract to C, and you'll just be left with the novated contract between B and C. Yes? Again, it seems like a relatively simple expedient, but one that will get you around the doctrine of privity. Then, but wait, there's more. There is the other ragbag bunch of ways around the doctrine of privity that I'm just not going to bother going into here, because you will cover them amply in other units by and large, or in other video series for contract law. So things like the imposition of a trust, you will cover in equity and trusts. In relation to the use of torts, actions in tort rather than actions in contract as a means to circumvent privity, you will cover that in torts. Equitable estoppel, you will cover in other video series in contract law. Restraint of trade, also you'll cover in other video series in contract law. Use of property, well, you'll cover that in the property-related subjects. And unjust enrichment, that's a bit of a head-scratcher, that one. There's been a bit of doubt cast on unjust enrichment and the reach of unjust enrichment, what exactly it does. We will touch briefly on that in another video series on contract law. But, look, I'm hoping by now you get the idea that there are many, many ways, different devices that can be used at common law and in equity in terms of trying to get around the doctrine of privity. And then you have the free set of steak knives along with everything else. You have the other various ragbag bunch of legislative efforts to get around the doctrine of privity. The Australian consumer law, which we have looked at in other video series in contract law, we have found that the doctrine of privity does not apply in two of the areas that we're interested in. Firstly, the statutory consumer guarantees. You will recall that consumers can take action against suppliers where those suppliers breach certain statutory guarantees that are contained in the Australian consumer law, things like fitness for purpose and acceptable quality and so forth. Now, if the supplier steps out of the scene, or you have trouble getting remedies from them, then you may well find that you are able to instead take action against the manufacturer. Section 271 is the section to look at there. Also, in relation to misleading or deceptive conduct, Section 18 provides for that, and it has been rather interestingly held that a third party to a contract can in fact take action where there has been misleading or deceptive conduct that tainted the original contract there. Accounting Systems 2000 and CCH is the authority for that. So we have, apart from the Property Law Acts, we have the ACL that assists us here, and there's still more, they just keep coming. Section 48 of the Insurance Contracts Act is a section that you should know about, and that provision is very important in the insurance industry in terms of getting around the doctrine of privity. Just accords with common sense and the things that Trident was on about, Trident and Knees. So persons named, for example, a subcontractor, can recover loss or for liabilities covered by the policy. Other legislation also applies: Marine Insurance Act, various motor vehicles legislation that deals with compulsory third-party insurance. You have legislative instruments that deal with carriage of goods, bills of exchange and checks, etc., etc., etc. You get the point. There are a myriad ways to get around the doctrine of privity, and I wasn't joking with my little Monty Python extract at the very top of this video series. It really does seem like a Trojan rabbit has been pushed up to the castle wall of the doctrine of privity, and a lot of little people have jumped out of that Trojan rabbit to try and lay siege to the privity concept. So that is privity of contract, and this is the end of our video series for privity. Like I always say, if you have any queries or questions, please shoot me an email, send me a tweet, post on Facebook. Most of all, keep in contact. I do look forward to seeing you again in a Zoom sometime, and until then, bye for now, folks.